Welcome back to LAWSTACHE channel. My name is Anton Vieltsin. I'm an attorney in the Southern District of California here in San Diego. This is my first video of 2023. But with YouTube and internet, you can never leave your past behind. Everything I've ever said on this channel is currently being said in someone's present. Meaning when I record this video, somebody watches it the following week. Everything I've recorded 2 or 3 years ago, someone might be watching now. So looking back at 2022, I realized that I made over 55 videos. And then I looked at the views, and there were 5 videos that brought the most views on this channel. In this video, I will go over those 5 cases that you thought were the most interesting for whatever reason, and then I will ask that young Anton from 2022 to help me along. I will cut some of those clips into this video, but of course, in order for you to understand the cases completely, go back and click at the links below where you'll be able to watch the full videos of those cases that were recorded a long time ago in 2022. So happy new year to you, and let's go ahead and look at these 5 cases.
Quick message from LAWSTACHE. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the LAWSTACHE YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the LAWSTACHE YouTube page. That's LAWSTACHE.
My most viewed video of 2022 was People versus Hester, which was a case that dealt with the California dirk and dagger law. And there the court held that even a 1-inch box cutter can in fact fit within the definition of dirk and dagger. And if you've been paying attention to Netflix, you might have seen the film Emily the Criminal. And there you've learned that a box cutter can in fact be used as a pretty serious weapon. And if you haven't seen the film, well, go ahead and go on Netflix and watch it. But anyways, in this case, the court differentiated between box cutters that are foldable versus the ones that are not, the ones that had a button to operate it and the ones that didn't. And at the end, it focused on knowledge and the ordinary use of a box cutter. And to understand a little bit more about dirk and dagger law, I invite that young Anton from 2022 to give us a little more information. Take it away, Anton. If the legislator had wanted to exclude non-folding box cutters from the definition of dirk and dagger, or to exclude all box cutters, as they choose to exclude all pocket knives, they would have said so. Our function is not to judge the wisdom of the statutes, nor are we empowered to insert what legislative body has omitted from its enactments, meaning that a box cutter with 1-inch blade that is non-folding does in fact fit within the definition of dirk and dagger. But let's go back to the original question. What about carrying it on you for innocent purpose, where you're not trying to attack someone? Well, here's what the court says. The concern expressed in the concurring opinion about statutory overbreadth is unfounded. The Supreme Court has held that the definition of dirk and dagger includes a knowledge element. Thus, to commit the offense, the defendant must still have a requisite guilty mind. That is, if the defendant must knowingly and intentionally carry a concealed weapon upon his or her person as an instrument that is capable of ready use as a stabbing weapon. In addition, in incorporating a knowledge element, the California Supreme Court has generally recognized when the defendant is charged with an offense that penalizes possession of an instrument that is ordinarily usable for peaceful purpose, such as a box cutter, it can be used for peaceful purpose. The defendant may justify the possession by showing the possession was in accordance with the instrument's ordinary legitimate design. Unsurprisingly, the video in the number 2 spot is Introduction to Conspiracy Law. In fact, this is the video that's first in a 9-part series. In 2021, I published a series dealing with vehicular searches without a warrant, and then last year in 2022, I made a series on conspiracy laws. Prosecutors love conspiracies, and if you want to learn more about them, you really gotta watch this series. In this first video, in the introduction, I give you the definition of conspiracy, which is an agreement between 2 or more persons to do something illegal, and then some jurisdictions require an overt act. I also give you the definition of overt act. We talk about Pinkerton liability, joinder, and then we discuss some defenses to conspiracy law. I'm not going to give you a clip from this video because you really got to go and watch the whole series starting from video number 1 all the way through 9. And if you want to master the art of conspiracies, well, you really got to watch this series. My number 3 video is United States versus Frazier, which was really a variation on the 2015 Supreme Court case Rodriguez versus United States. And if you remember Rodriguez, it dealt with prolonged stops, meaning that every minute, every moment that a trooper is not using to write you a citation and instead doing something else, like waiting on a dog, a canine, to come in to sniff around the car, if he is not actively pursuing the initial stop, the initial citation, he's illegally prolonging the stop, according to Rodriguez. And all the evidence that he finds later might be suppressed and cannot be used against you. In order to understand a little bit more about Rodriguez, I again invite that young Anton to take it away and tell us a little bit more. So the stop started at 9:07 and they found the pills roughly at 9:26. So we're talking about roughly a 20-minute stop. But remember, the timing itself is not important. I've published the case Rodriguez on my website before. I've explained it many times on this channel, and I still get comments in my videos saying whether 15 minutes or 20 minutes or 30 minutes becomes unreasonable, but that's not the standard. Under Rodriguez versus United States, and here's the citation from 2015, the Supreme Court tells us that the seizure of the passenger or other passengers in the vehicle ends when the tasks tied to the traffic infraction are or reasonably should have been completed. Meaning that when the driver and the passengers get pulled over for a traffic citation, the officer has to start issuing that citation. He has to do those standard procedures. And if he doesn't, he's prolonging the stop. There are 3 factors that we look at. Whether the officer diverts the investigation into a general criminal investigation, meaning that instead of issuing the citation, we're now in the general criminal investigation of something else, whether he prolongs or adds time to issuing the citation, and finally, whether that detour on unrelated issues is supported by reasonable suspicion. My number 4 video is People versus Torres, which dealt with pretextual inventory searches. Young Anton, tell him what that's all about. When we're talking about inventory searches, we need to focus on the purpose of the impound rather than the purpose of inventory. There are 3 reasons to impound a vehicle, and all of them stem from the community caretaking functions of the police. First, it is the protection of the owner's property while it remains in police custody. It is also the protection of the police against claims or disputes over lost or stolen property. And finally, the third reason is the protection of the police from potential danger, items that can hurt the general public or the police that are inside the vehicle while it is being impounded. Now, the decision to impound the vehicle must be justified by one of those 3 community caretaking functions, other than the suspicion of evidence of criminal activity. Finally, my 5th most watched video of 2022 was United States versus Martin, which dealt with the knock and talk doctrine, allowing the police to do exactly that, to come up to your front door, knock on it, and talk to you. Let's take a look at some more details from the case itself. The Fourth Amendment protects you against unreasonable searches and seizures, and generally speaking, police needs to have a warrant before they can enter and search your home. And when we're talking about your home, we're including curtilage. Curtilage, under the Constitution, is the area that surrounds your home, and that the Supreme Court has acknowledged that you have an interest in that area, and you want to make sure that people don't enter that area and don't trespass upon it, even if you don't have fences around your yard. But there are exceptions to the warrant requirement. One of them is knock and talk. This is the exception that permits police to encroach upon the curtilage of a home for the purpose of asking questions of the occupants. It's exactly what it sounds like. Police comes up to the front door, knocks, and wants to talk to the person inside. Why do we allow police to enter this curtilage area for the purpose of knocking on the front door? Well, it really comes from implied consent, which comes from customs. In the United States, regular people can come up to the front doors and knock and try to talk to the owner or the occupant of the home, including the police. Police can do everything that a regular citizen can do. Of course, there are limits on how police should conduct a knock and talk, and it is not with their firearms drawn. I will tell you, this case was a complete mess, and I invite you to click on the link below and watch it in full. And of course, the other 4 videos, I also ask you to rewatch those. They're very interesting. You said it yourself. According to the views, they're the top 5 videos. And finally, I want to thank you for watching me or listening to my podcast in 2022, and I will bring you more content in 2023. If you're on YouTube, please like, subscribe, hit that bell notification button so next time I post, you'll be first to know. If you're listening to the audio recording on Spotify or Audible, give my podcast a 5-star review rating. And finally, I want to thank all of you that purchased my merchandise in 2022. And if you're interested in the t-shirt that says "Do not arrest this person" or some of my other merchandise, I invite you now to go on LAWSTACHE.com, where you will find all of this merchandise. Again, Happy New Year, and I look forward to bringing you more videos in 2023. Thanks for watching.